Assalamualaikum warahmatullahi wabarakatuh. I am Ahmad Zikri bin Muhammad Bukhairi. Entry number 115.912. I will present to you about the case of GREATREX and WIILIAMS in 1957. First, we go to the fact of the case. In 28 May 1946, the appellant, the GREATREX, or the vendor, made an agreement with William as the respondent and William also as the purchaser. This is the appellate case. They had entered an agreement in 28 May 1946 where the vendor want to sell 34 lot to the purchaser, and the agreement contained 3 clauses. Clause 1 said that the agreement, the vendor and the respondent agree to sell and the purchaser agree to buy, and clause 2, the seller, the vendor, provide that purchaser should can build on the land, and the third, upon the respondent or the purchaser pay the deposit, they can erect any building on that. Deposit is 10% of the purchase price. And in October 1946, before that, this is before the agreement was made, the purchaser William had built the 2 houses on the plot 1 and plot 2 of the 34 plot before that. So the conveyance had occurred on July 1946, and only in October 1946, the respondent paid the deposit 10% from the purchase price. Upon paying the deposit, respondent enter to the plot 3 and plot 4, and he built the fence, the wire fence, all around the whole plot. And then in April 1947, 1 year after the agreement was made, the purchaser had come, the vendor had come to the purchaser and ordered him to get off from the land. So the purchaser being set, and he had do nothing, stop to build anything to the land, and he had do nothing about from the said land. And in the period of 10 years after that, the purchaser also had come to the land. He built a garage, and sometimes he lived in the garage for a few days in a shorter time. After that, after 10 years from the agreement was made, the vendor had offered the third party, and they had made a contract. The vendor had sold the land that belonged to the purchaser 2 times from the normal price that the contract was made in 1946. It is twice the price. Price is twice that. And the purchaser knowing the vendor want to sell the third party, the purchaser had sued the vendor. He claimed for specific performance the vendor, because the vendor had sold the land. The purchaser claimed that he has equitable right to the land because he had paid the deposit although he had not paid in 2 years. I forget to tell you that the agreement said that he must pay the purchase price of every plot within 2 years. That's all about the fact.
My name is Muhammad Afiq Faiz bin Muhammad Sali. My material number is 111519008. And next we will proceed to the issue, explanation, principle, and also the help of the court in this case. First, the issue in this case is whether the purchaser has equitable interest over the land that had been paid depositly and had been abandoned for a few years. Then we go to the explanation and also the principle. The contract made by both parties had stated that the purchase of any plots must completed within 2 years. The terms showed that the sale and purchase of 34 plots within 2 years was severable or separated, and provided the completion of separate contract, one in respect of each plot. Then, the time was not of its essence in this agreement, and the failure of the parties to complete within the stipulated 2 years was not a bar to the present action. Then, the purchaser had paid the deposit, and having they entered into the possession of the land, he had become the equitable under, and the contract as when the deposit was paid, there will be a binding contract. It was binding even though that the vendor kept the check on his pocket. The appellant had made an objection on the ground of laches, despite that the vendor had ordered the purchaser off from the land. He had done nothing to see the fence was removed or to take down the garage. This showed that the appellant had not showed sufficient acquiescence on the purchaser's act of possession. The lack of evidence of the purchaser had abandoned the land also shown, as he had entered and built a garage and had lived in it, although in a short time within the period of 10 years. The help of the case, the court dismissed the appeal. The purchaser had equitable rights as the contract made between them was not registered. The lapse of time, the purchaser was entitled to specific performance on payment of the balance of the price and interest thereon for the intervening years. That's all from us. Thank you.